lawyers fit in this segment of the economy that's subject to cost disease. What makes law different than medicine and higher ed is that consumers have kind of sucked it up, and we're paying more of our income for healthcare. We're paying more of our income for higher ed when we send our kids to college. The economy, at least in the people law sector, is choosing to is foregoing legal services, and so the basket of consumer goods from the Bureau of Labor Statistics shows that consumers are buying less law over time. They're figuring out ways to go without. I just won't hire a lawyer. I just go without, and that's a very, very dangerous place to be.
Today on Law Next, should ethics rules be changed to allow non-lawyer ownership of legal services providers? My guest, Bill Henderson, recently presented a legal market landscape report to the State Bar of California in which he pretty much recommended just that, and the bar has appointed a task force to further study the issue. This is Bob Ambrogi. You're listening to Law Next, the podcast that highlights the innovators and entrepreneurs who are driving what's next in law. And if anyone fits that description, it's Bill Henderson. He's a professor of law at Indiana University Moore School of Law, where he holds the Stephen F. Burns Chair on the legal profession. He's also an editor of Legal Evolution, an online publication he created that focuses on the changing legal industry. The ABA Journal named him a legal rebel. The National Law Journal called him one of the 100 most influential lawyers in the United States. And National Jurist named him the most influential person in legal education for 2 years in a row.
We'll get to today's interview in just a moment. But first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview.
Bill Henderson, welcome to Law Next.
Thanks, Bob. I appreciate the opportunity to be with you.
Bill, in preparing this legal market landscape report for the State Bar of California, we're going to get a lot more into the weeds about it, but what was the charge to you? What did they want you to do? Why did they approach you in the first place about this?
A great question. The State Bar of California recently was subject to new legislation, and historically, just to give a little bit of background, California is a unified bar. Their members were elected by the membership, but a change in the state law made the trustees of the State Bar of California appointed. Some were appointed by and they're in a transition period. But when the legislation's fully in place through the transition period, some members will be elected by the General Assembly. Some members will be appointed by the governor, and some will be appointed by the state Supreme Court. And there'll be 6 of the 13 members are going to be public members, so they're going to be non-attorney members. And the charge on the state statute is to regulate for the protection of the public, which is rhetoric that comes from the common law of lawyer regulation. But because of this kind of new focus, because the trustees were going to be appointed as opposed to elected by the membership, the executive director and the chairman of the trustees said, we need a landscape report so we can look at these things fresh and possibly look at ways to improve the function of law for the citizens of California. They really were looking at this thing from the point of view of how do we best protect the public, and so that was the charge here. Let's get a fresh look with the new group of trustees, and let's give them a fairly comprehensive but concise explanation of what's going on in the market. I was given the job of writing that up.
It's interesting you talk about the charge to the State Bar, because I actually watched your presentation to the State Bar was webcast and recorded, and at the end of your presentation, the chair of the Board of Trustees, I guess, of the State Bar made the comment that I thought was really interesting, which is he said that they have 2 goals. One is to regulate and screen the legal profession in order to prevent clients from being harmed, I guess. But the other is also to increase access to justice. And he made the statement that those 2 goals are in tension with one another. And in a lot of ways, that's exactly what you found in your report. So you conducted this landscape report, and in the opening, I kind of characterized it as that you made a certain recommendation. I don't know if you would call it a recommendation or a conclusion, but why don't you give us? We'll talk about the details a lot more, but give me your overall conclusion or recommendation to the bar.
Yeah. Well, the one that's gotten the most press and the most interest is a recommendation that the state bar consider lifting the prohibition on non-lawyer ownership, which is the historic ban on non-lawyers having an equity interest in any business that practices law, Rule 5.4. Having done this report and thought deeply on this issue, it's not my conclusion is not really that we need access to capital. We can have a conversation about the role of capital, outside capital, to spawn innovation in the legal service industry. It's primarily to get lawyers to be able to collaborate at a very intimate level with allied professionals to solve this productivity problem. The lead of the report really is the problem of lag in productivity that not only it affects the people law sector, individuals so much that they pretty much can't afford a lawyer to resolve their dispute in court. So you got the state courts glutted with pro se litigants. State court judges understand this issue very well, and you just can't afford it's just not cost effective to hire a lawyer to deal with that. At the other end of the spectrum, with Fortune 100 clientele, they're complaining about the price of legal services, and step one has been to insource it by bringing up their in-house legal departments, and that's proven to be pretty expensive over a period of time. Some of it is going to alternative legal services providers, but you have both sides of the spectrum. Individuals with modest incomes in Fortune 100 both saying that they can't get what they need from the traditional market, and so they're having workarounds. LegalZoom has come in at the people law side to begin to speak to that need, and alternative legal service providers are addressing that. On the other side of the spectrum, we've got this big landscape in the middle where I think people realize that the cost of legal services are very, very high, and there's got to be new ways to kind of pick up on what Susskind talks about. We're moving from a one-to-one to a one-to-many service delivery capability, and the only way we can make that happen is collaboration between lawyers and allied professionals. And 5.4 is just like it makes these professionals the employees of lawyers, and the lawyers aren't fit to manage them. They have to be co-equal. And so it's primarily to facilitate collaboration for innovation as opposed to need for capital.
Well, that's the word you use a lot through the report is collaboration. I mean, how does the rule as it stands now inhibit or prevent the kind of collaboration that's needed in order to bring about these changes?
Well, for those that are kind of familiar with going to industry conferences, we hear more and more blowback regarding the use of non-lawyers. Now, that's a term of art that's actually in the professional rules of responsibility, but it's to be used in the course of business in your organization as you're trying to get stuff done and meet the needs of your clients. To call somebody, well, he or she is a non-lawyer, is a pejorative way of referring to somebody that has a skill set that the lawyer clearly lacks. And
very
I think
much
that,
these days, there's a lot of discussion around that.
And the fact of the matter is that by making the lawyer the equity holder, you're putting somebody in charge that doesn't see the full scape does not see the full scope of the problem. We need help from a technologist. We need help from a process person. We need sales and marketing expertise. And by having the lawyer want to control, and largely, if you look at it from a law firm's point of view, large law firms make a lot of money, and their charge is largely to preserve those high profits per partner. And the idea that we're going to hire allied professionals to preserve the high incomes of these folks, and they're all going to be employees, it's just not a way to organize an organization that's going to innovate in the client's interests. And so And the flip side is that all these companies, like there's some great alternative legal service provider companies out there that I think are getting some of the best talent, but because they can't have in their organization somebody who actually practices law for a living, it inhibits those organizations from getting really kind of great opportunities to innovate. And so 5.4 is just, I think, is inhibiting this effective collaboration across organizations.
We're kind of on the road to this already, aren't we? Or pretty well down the road to this already in the United States, in a sense. In that, as you just alluded to, there are any number of private companies that are providing legal services in one way or another in the United States, from LegalZoom and Avo on the consumer side to some of these alternative legal services providers on the corporate side. I mean, does it kind of feel to you that it's inevitable that we're going to get to a point of basically abandoning the non-lawyer ownership rule?
Well, you raised a good point that it's happening already. We haven't changed the rule, and we see this ferment taking place in the market, and so we're heading down this road. I think liberalizing that rule will speed up the pace of innovation. I should say that I was long in the camp of a group of academics that just say, why are we bothering thinking about Rule 5.4? The politics of it are such that it'll never change. Let's figure out workarounds because the capital needs to flow and the talent needs to flow to the places where we can deliver value amidst this regulatory language. And my counterpart, Gillian Hadfield, who's written extensively about the need to liberalize Rule 5.4, primarily for the people law segment. I would see her at conferences, at industry events, and I would just say, Gillian, I just don't think this is worth our time here to focus on this issue. And then I get the call from the California bar to write this landscape report, and realize that there was a group of regulators that were in an environment that was kind of used to going first, and that had within their state all the different. There's law companies in California. There's elite law firms in California. There's a vibrant people law market. LegalZoom is headquartered in California. A lot of the innovators are part of the state economy. And realized that this is a group of people that were willing to go first. And so I actually sent a note to Gillian after I wrote the California report and said, well, Gillian, I was wrong and you were right here, that this is actually, it's possible that one state could take the lead and get others to fall in line here. And so I think that Bob we're going to continue to see innovation, but liberalizing the rules would really accelerate it. And I think the biggest issue to me is the idea that you're going to get the very best talent who could be a partner with the law firm to create something really great for a client base. And it's that co-equal, that ability to treat each other as peers, that I think will allow law to tap into the best talent. And actually, I think kind of level the attitudes of partners that are used to being in charge and want to be in control, to have somebody be their co-equal and having to kind of give them equal floor, kind of airtime. I think that is just absolutely crucial toward accelerating development. You want the best people to charge and everybody to get airtime that has them to contribute, rather than the privileging one group over the other. I just think that's going to hurt the industry.
We'll get back to my interviews in just a moment. But first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview.
So there is some reason to these rules, in the sense that there was a reason they were written in the first place, and many would argue there's still good reason for them, and probably the primary argument for the non-lawyer ownership rule is that lawyers need to be able to maintain, independence in exercising their professional judgment. They shouldn't be answerable to some corporate overlords. Do you reject that idea? How do you handle that issue?
I believe it's very, very important. I think the greatest asset a lawyer brings to a client is intelligence combined with objectivity. I've actually used lawyers in my business and my personal life, and as a client, I say, your job is to tell me where I'm wrong. Please, and maybe I was the ideal client in that respect, but that objectivity is really what a client needs, not necessarily what they want. And I think that that's really, really important. Those rules cut specifically in the direction of asymmetric information, where the lawyer has superior knowledge and the client has less knowledge. And so you don't want to have the lawyer having to think about a third party that they have capital obligations to. But in a world where most legal services, and the California report touches on this one, probably over 50% of legal services are sold to an organization that has an in-house lawyer that's making the buy decision. Those rules of information asymmetry really don't apply. And so on a policy level, over half the market, that the rationale for it probably does not apply to them. The second issue, and I'm sympathetic to this idea of lawyer independence because I value it. I think that there's other ways to preserve lawyer independence. There can be compliance regimes that apply to lawyer entities that have to preserve the independent judgment of the lawyers. I think that it should be a regulatory goal, but I think that this particular rule is over-inclusive. And it inhibits that collaboration that I've emphasized so much in the report.
So let's say the California Bar, the California Bar, based on your report, voted to appoint a task force that's going to study this issue in more depth, as I understand it. And let's say they study it, and sooner or later the California Bar kind of follows your lead and says somebody's got to be first, and we'll be first on this. How does the world of legal services change after that? Do we still have an access to justice problem? What does the world look like after we allow private investment in legal services providers?
Bob, that's a great question. And when I was addressing the California Bar, I try to highlight the fact that this is not a silver bullet. We're gonna if this rule gets changed, people will realize the possibilities that may come about through this change here. And some organizations are going to slowly adapt their capital strategy to optimize for it. I mean, in the UK, the Legal Services Act was passed in 2007. The alternative business structures didn't come online for 5 more years, and the ability to measure the impact of those ABSs is probably what we still aren't in a period now where we could measure the impact. So 10, 15-year time horizon to see real material results, that would be point number one. Point number two is and I tried to emphasize this to the trustees, is that a lot of the access to justice is really at the courtroom door, where it's just too expensive to hire a lawyer to solve your legal problem. Lawyers, there could be meritorious cases, but the lawyers can't cost effectively manage them. And something that's not in the control of the California Bar is how the state chooses to resolve disputes. And it's touched on in the report that perhaps we should be looking to something besides an adversarial system where both sides are expected to bring an advocate to court, which is a place. There's pretty good evidence that a large number of disputes can be handled effectively with an online dispute resolution system. I touch on the one that's in place in British Columbia and Canada. Tyler Technologies, which acquired a company called Modria, is now providing similar services in the counties that comprise metropolitan Austin in Texas. They call it pajama justice because you can fill out your complaint in your pajamas. I think that has nothing to do with this report, and that's really where the access to justice issue is going to get solved. The idea of how do we design, it's a design problem. How do you design a dispute resolution system that's efficient, that's fair, that's viewed as legitimate, that can deal with smaller state disputes. Now, in the British Columbia, you can't bring a court into the ODR process if it's under $5,000. There's no court. There's no lawyers that are involved here. There's a case manager that uses mediation principles, and a lot of it is done online, and it's getting pretty good marks. And I think that the access to justice thing is partially disconnected from the Rule 5.4 issue. The 5.4 is going to create products to solve legal problems that don't involve court. And so I think that there's many layers to this problem, but 5.4 is no silver bullet. If we change the rules, we'll get results in 8 years, 10 years. But because it's going to take so long, why are we waiting?
Yeah. So the results that we will see then would be law firms making better use of technology, making better use of business methods, becoming more efficient, being able to lower their prices. Is that how you see it?
Yeah. I'm not sure if I would say it's exclusively law firms. It could be a law company. Yeah. But enterprises. I think that there's a real opportunity out there, and it depends upon whether we're talking about the people law sector or we're talking about the organizational client sector. But this idea that you could provide your client with something much, much better, much more efficient. Your costs go down, and maybe your overall revenues go down, but your profits actually go up because you figure out a more efficient way to do it. And I think that it will probably lead to some market consolidation because a lot of the solutions that lever off of these productivity technologies or processes require scale to work. And so it probably will lead to some sort of a consolidation. We'll have to deal with the conflict rules that'll have to be sorted out over the next 10 years if we go down this road here. But there's a real opportunity to do more with less, and that will actually tap into a latent demand for a law. And I think it will, as I said in the report, I think it will improve the esteem of the profession because ultimately people can access what they need more conveniently, more cost effectively in a way they're used to buying other goods and services. We don't need to have law be an intimidating subject. It should work. It should work well. It should work for the benefit of the people.
How does it get regulated when it starts happening? I mean, if Walmart is suddenly providing legal services, is there still a role for the state bars to be regulating that provision of legal services?
Yeah. I'm a little worried about kind of like using the Walmart example here because it kind of loads the conversation. But
you don't think it's going to happen?
Well, there are certain healthcare features that are done at like a CVS or done in a Walmart, and there are certain types of mundane legal things that perhaps could be done in conjunction with a sales channel like a Walmart. And I'm not against that. If the citizens like it, if it's working out well, that would be great here. I think that we actually have a tort and contract regime, common law regime that could probably handle this of the guaranteeing the merchantability of this of these legal products. I think that really when we're looking at this issue, we should be looking at all the harms that could happen, and we lawyers are experts at spotting what could go wrong if we go down this road, but actually the benefits that it could accrue to the public. And the status quo it's clearly not working for individual student or individual clients because half of the people in state court are unrepresented, and God knows how many don't go to court at all because they can't afford a lawyer. So here you find yourself in court, you don't have representation. The state court judge is mired in inefficiency because of this. I mean, there needs to be a better way to provision legal services. Some of it preventively, and some of it through redesign of processes.
Yeah, well, you're preaching to the choir and talking to me on that point. But one point you made in your report that I thought was really interesting is a simple one, but it's that we focus so much on regulations in law designed to protect consumers, but those regulations are really only protecting that small percentage of consumers who have access to legal services.
Yes.
And they do nothing for that other 80 to 90% of people who don't have effective access to legal services. Are we nearing a point where we just have to kind of rethink the whole concept of professional regulation?
I believe that the answer to that is clearly yes, that we need to not amend these rules, but we think about a new regulatory structure. Somebody's going to have to go first to do this lift. There's going to be some benefits to going first to setting the model, but lawyers are pretty good at thinking through these types of issues, and there's a lot of lawyers that support liberalization. They want to construct something that's in the public interest that works better, not only for citizens, but a lot of lawyers can benefit from this. Or a lot of people they see a better, more sustainable model that they feel proud of, and so we can figure it out here. But I think it's time for a clean sheet operation. We'll look at the UK, we'll look at Australia, but I don't think we can amend the model rules here. All this regulation is being done. We're regulating it with the presumption that it's a client-lawyer relationship. Legal solutions need lots more than one lawyer looking at statutes and looking at case law to solve their problem here. That's a multidisciplinary play, and so the idea that we're having a lawyer-client relationship, we're using that to regulate all of law, is I think where we're getting into serious trouble, because it's inhibiting the collaboration to deal with scalable solutions, the one of the many that Susskind talks about.
So when you talk about that, one of the key theme of your report in a lot of ways is what you call this problem of lagging productivity, and that the issues that the solutions you discuss could basically help enhance productivity. But whose productivity are you talking about there? I guess what I'm really asking about is, do you see this as a matter of letting lawyers do more, or do you also see this as a matter of increasing the scope of those who are able to provide legal services beyond the sort of traditional definition of a lawyer?
It's a really good question. I want to just give a little bit of framing to this, because there's a section in the report that talks about this idea of cost disease, and so kind of do some definitional stuff here. Cost disease is this idea that certain things in our economy, I would put foodstuffs, manufacturing technology, is on a cost curve that continues to go down. And so I bought a car 20 years ago. I paid the same amount for a car I bought recently. The car's way better. As a consumer, I get huge benefits from that enormous productivity gain. There's certain human intensive activities in healthcare and higher ed are kind of leaders in there, that they're inherently human intensive. And when you combine an economy, these areas of the economy that are hyper productive, technology just speeds up the quality and drives down the cost, and you put it with human intensive activities, you fundamentally give a pay raise to doctors and college professors and frankly lawyers. Lawyers fit in this segment of the economy that's subject to cost disease. What makes law different than medicine and higher ed is that consumers have kind of sucked it up, and we're paying more of our income for healthcare. We're paying more of our income for higher ed when we send our kids to college. The economy, at least in the people law sector, is choosing to is foregoing legal services, and so the basket of consumer goods from the Bureau of Labor Statistics that pulls the stuff together shows that consumers are buying less law over time. They're figuring out ways to go without. I just won't hire a lawyer. I just go without, and that's a very, very dangerous place to be. So part of this would be like LegalZoom is the best example of productivity where you can get a pretty good will, you can get a pretty good trademark application. It's very convenient to access. I won't attest to the quality of it because that'll probably get me in trouble. But it's convenient and it's easy to use, and LegalZoom seems to have built a business out of it. That's increasing productivity. That's solving a legal problem at a price point and a convenient level that's attractive to a lot of people. That increases. That's a tremendous increase in the throughput of solving legal problems in a proactive way. The flip side is that as long as the state sets the procedure for how we solve disputes in contract and torts, whatever, that's inherently labor intensive. And so this means that when our disputes get solved through a court, well, it's too expensive to go to court, so I just won't go to court. Or if I go to court, I won't go to court with a lawyer. That's the kind of the meltdown dynamic that's taking place because of this cost disease. And then at the other end of the spectrum, in the Fortune 100, I mean, it's staggering how much legal complexity there is to run a business that cuts across international boundaries. And they're the ones that are leading the way with this legal operations movement. And that is inherently multidisciplinary, and they've solved the problem because, like say Cisco, for example, 450 FTEs, 280 of them are lawyers. Mark Chandler and Steve Harmon, who run that place here, just hire the best technologists. They hire the best process people, and they become part of the team because they have to be compliant in this world here without spending too much. And so they spend about 2.5% of the total company revenues on legal services, but that's a profoundly multidisciplinary environment that you're operating into, and it's outside of the scope of 5.4, and it's all about productivity. It's all about doing more for less. And so I hate to just fall back on examples, but I think that's probably where we're safest. LegalZoom on one end and Cisco on the other, both focusing on productivity issues.
So, Bill, I know that there's a lot that you covered in your legal market landscape report to the State Bar that we haven't been able to talk about on this show, and I would encourage listeners to go and find that full report and read it through. It's a little over 30 pages in length. It's a fascinating read. You really do paint an in-depth and intriguing portrait of the legal market as it stands. And as we kind of alluded to, you talk about the kind of two hemispheres, and hemispheres may not be the accurate word, but these two parts are sort of the consumer law side of it and the enterprise law side of it. You can find it at Bill's legalevolution.org site. It's also on the State Bar of California site, but maybe a little bit harder to find there. But so before we go, I mean, I've asked you a lot about the report, about this issue, but I wanted to just ask you what stands out for you on this. That what's your big takeaway on this that you wanted to kind of leave as your closing thought?
First of all, Bob, thanks for having me. Legal Evolution post 58. If you go to that sub website or that post on Legal Evolution, you'll find a link right to this report on the California State Bar website. My big takeaway from this is that it's really not about inviting the capitalists in because we need their capital, because some lawyers are still making plenty of money here. But it's really about creating a vehicle where the very best people can work together to solve very, very serious problems as fast as possible, and permitting a horizontal level of management and risk sharing, and in a collaborative way. That is key, and we're seeing some companies struggle to bring this about here. I mean, LegalZoom is done on one end of the spectrum, and there's some great companies that are doing it on the other. But this 5.4 issue is something that I see again and again and again. Me trying to engineer around, whether we're looking at Elevate or United Lex, there's a variety of companies that ClearSpire, what they did, Atrium, that they're going to elaborate lengths here to facilitate this kind of collaboration. And I think that it's really about collaboration. It's not about the need for money. If you get the people to collaborate, they're going to work together for 5 or 10 years to create something that's great, and they're going to have sweat equity in it. That's the way it should be. Have a good idea, work very hard at it, get it to have your product market fit, and then the people that collaborated can benefit in it. I just think that innovation law is too slow a bake. It's not about lending the venture capitalists in and the private equity folks, and I actually think that it's probably a little counterproductive to invite them in because they're not going to get a fast enough return. But I think that letting these people collaborate to really solve difficult problems of more for less is the way to go here. The takeaway is laws is going to be a highly multidisciplinary field in the years to come, and whether we change the rule or not, that's the way it's going to be. If we change the rule, we're going to bring that about sooner and better.
I kind of think it's going to change sooner or later, and I hope sooner, and I hope a lot of people read your report and give it some careful thought. And thanks for being my guest today. Thanks for all you do to drive forward thinking in the legal profession. Really appreciate your time today, Bill.
Bob, appreciate to be on your show, and you're doing a great job locating innovators, and you've always got a great way of bringing out the best in people.
Thanks. Well, that does it for today's show. If you like what you heard, please head on over to Apple Podcasts and leave a positive comment. We would love to have you do that. And you can also sign up there or at lawnext.com to receive future episodes and be notified when we have future episodes. Thanks for listening. This is Bob Ambrogi.